Hello, and thank you for tuning in to MEMO's Weekly Review with me, Nasim Ahmed, and my regular guest, Mouin Rabbani. Hi, Mouin, how are you doing?
Hi, Nasim. Hope you're well. Always good to be with you.
Likewise. There's a lot to talk about. I think we'll
Yes.
spend most of our time on the recent ICJ ruling, the landmark ruling from last week. We'll discuss that, dissect that in detail. And then we'll move on to the spike in Israelis leaving the country post 7 October and discuss the recent attack on Yemen's port city of Hodeidah and the regional response from that. And there's also reports that one of Israel's port, Eilat port, has become bankrupt due to Houthis' naval blockade. So the significance of that. And of course, we'll end with the show with a look at the US, President Biden's legacy. Is it rescuing? I mean, Biden has, of course, said that he will not challenge the next US election. So is he rescuing US democracy, as many say, or is his legacy one of being complicit in a genocide? So we'll be asking that as well. But let's begin, Moin, with the ICJ ruling from last week. I listed something like 10 Israeli violations that was mentioned in the judgment itself in total. But let's just begin with getting your initial thoughts about the ICJ ruling.
Well, I think it would be useful to first talk about how this case came about, because I think that's an important aspect. This was not a case brought against Israel by the Palestinians, or as in the genocide case, by the South Africans. What happened here is that the United Nations General Assembly, in other words, the international community, as it should be properly understood, requested an advisory opinion from the International Court of Justice. An advisory opinion sounds quite banal, what do you think? But we need to bear in mind that the International Court of Justice is the highest court in the world. It is the Supreme Court of the United Nations, if you will, and that it is the authoritative interpreter of international law and of UN rules and procedures for the United Nations and all its organs and agencies. Now, the General Assembly, indeed, largely as a result of preparatory work done by the Palestinians, but it was ultimately the international community rather than the Palestinians who, in this case, went to the court, asked the court for its views on the legality of Israeli rule in the occupied territories. And the question at stake here was, is Israeli rule in the West Bank, including East Jerusalem, and the Gaza Strip a military occupation, which has a recognized status under international law and is not by definition illegal, or rather has the nature of Israeli rule in these territories exceeded anything that can be legitimately be defined as a military occupation? And is it in fact a process of annexation and therefore no longer legal, illegal, illegitimate, unlawful? The court considered this question and it accepted numerous submissions from numerous countries, the usual rogues gallery coming out in support of Israel, and the Palestinians and many others coming out in support of a proper understanding of international law. And this case, while the focus has been very much on South Africa's case against Israel under the genocide, for very good reason, I should add, this case originated, in fact, in January of, I believe, was it 2021 or last year? I think last year. And the court this last week gave its ruling, issued its advisory opinion, and it was absolutely devastating for Israel. The court noted that a military occupation, in order to conform to international law, must be of a temporary nature. And it determined, I think with very little effort required, that Israel intends its rule in these territories to be permanent, and that it is therefore not a military occupation, but an annexation, and that it is therefore illegitimate and unlawful and illegal. And essentially, it determined that Israel has no right to rule these territories. It has no right to be in these territories. And then it gave a number of subsidiary rulings that all the settlements, without exception, are illegal and illegitimate, that all settlements must be dismantled, and every single settler must be removed from these territories, that Israel, having indexed the voluminous violations of the fundamental Palestinian right to self-determination recognized under international law and a variety of other laws, that Israel must provide reparations to the Palestinians that Palestinians incurred as a result of these numerous violations since 1967. And then it also issued a number of rulings regarding the United Nations and its member states, particularly that states are under an obligation not to recognize any Israeli attempts to change the status of any of these territories, and essentially that they must deal with the situation as one of illegality. And there are a number of other rulings. Now, the question becomes, you hear the term advisory opinion. What does that mean? Well, perhaps in a technical legal sense, this ruling is not comprehensively binding, but it is binding on the party that requested the opinion, namely the United Nations. And it sets forth a number of obligations on every member state of the United Nations. So it is authoritative, and if in some respects it is not binding, what, for example, the legal scholar RDM Sis, who was a member of the Palestinian delegation, has noted, is that so much of this ruling relies not on legal innovation, but on issues and points that the judges themselves note is customary international law. In other words, by definition, binding on the international community and its individual members. So it's an absolutely landmark decision. It's a devastating decision for Israel. And one of the key consequences is that it has resolved so many issues that these are no longer subject to negotiation. Borders are no longer subject to negotiation because the ruling is absolutely clear on this. Settlements are no longer subject to negotiations because each and every single one of them is illegal and must, as a matter of international law, be dismantled and removed, and so on and so forth. So one can look at it as the biggest, if not the final, nail in the coffin of the Oslo process that sought to transform the status of these territories from occupied territories to disputed territories in which Palestinian rights and Israeli claims were effectively treated equally, and that the dispensation of these territories, of their borders, of the settlements within them, and so on, was made subject to negotiations determined by Israeli interests and aspirations rather than by international law. So it's a landmark decision in every sense of the word.
Let's unpack that. I mean, you mentioned a number of points there, and we'll need to unpack that in more detail. And I think one of the things that's really crucial to understand here, for me anyway, is the fact that, the media can no longer say disputed territory. The law has fallen on one side. And for many, many decades, Palestinians have always been bewildered by the fact that the law has been parked on the side for this roadmap to peace or negotiations. And that's something also that can be ended for what is now a conclusive, definitive statement from the ICJ, and that's a massive progress for anyone who wants to live in a rules-based international system. What that means we can speak about later, because I have a lot to ask you about that as well. But one point I want to begin on is how the judgment itself can have an impact on the ICJ determination on the genocide case and also the ICC case as well, because one of the points that was clearly made is that Gaza is occupied territory, the West Bank is occupied territory. There's no disputing that now. So in what way does that determination affect the way we look at the October 7 event? One of the arguments I remember right at the beginning that was made by a brilliant lawyer was the argument that an occupier cannot claim self-defense to maintain a state of illegal occupation. And the argument was made in a really compelling way. So just to rephrase the question again, so how does this reframing that the Gaza Strip is occupied territory and an occupier cannot claim self-defense to maintain a state of illegal occupation, how does that framing change the way we look at 7 October?
Well, you've raised a number of issues, so please do remind me if I neglect any of them. Let me start with a comment you made that media and others can no longer refer to disputed territories. That's entirely correct. I would go even further and say they can no longer refer to occupation. Henceforth, if they want to be accurate, they need to consistently and exclusively refer to it as the illegal and unlawful and illegitimate occupation, because again, military occupation in and of itself is not illegal or unlawful or illegitimate. It has to conform to a number of conditions. A key among them is that it is temporary in nature. And what the court has said is that this can no longer be characterized as a military occupation. It is, in fact, a process of annexation, and as such is illegal and unlawful and illegitimate and must end as rapidly as possible, and that the international community has an obligation to ensure that it ends as soon as possible. Now, let's take the issue of the Gaza Strip. As you know, Israel unilaterally disengaged, to use its own words, from the Gaza Strip in 2005. And the claim made by Israel at the time was because it removed its military bases and its settlements and settlers from the Gaza Strip, it was no longer an occupying power in the Gaza Strip. Almost immediately, the International Committee of the Red Cross, which is a custodian of the Fourth Geneva Conventions, and human rights organizations and many other authoritative interpreters of international law, said that in fact, Israel, because it still exercises effective control over the Gaza Strip, over its borders, over its airspace, over its territorial waters, over its electromagnetic sphere even, because of these factors, Israel is still an occupying power. And what the court has now done is reconfirmed that not only is the Gaza Strip still ruled by Israel because of these reasons, but also that the Gaza Strip and the entirety of the West Bank, meaning including East Jerusalem, form a single indivisible territorial unit as far as politics and the law are concerned. You know, some Israelis have tried to refer to what they call the state of Gaza as if it's a separate entity, a state, if you will, and that therefore the current hostilities are an interstate conflict between Israel and the Gaza Strip, akin to that between, let's say, the Russian Federation and Ukraine. And what the court has said is that no, the Gaza Strip is an occupied territory, and so therefore this can by no means whatsoever be considered an interstate conflict. Now, this is important in legal terms because under international law, an occupying power does not have the right of self-defense against the territory it occupies. It has a right to protect its citizens from harm and to prevent harm to its citizens. But the rules that apply there are quite different than those that would apply to, let's say, a regular interstate conflict, and the right of self-defense does not enter into that equation. Now, regarding your question about October 7th, I don't feel I'm qualified to answer that because, of course, what happened on October 7th, it was not a Palestinian uprising within the Gaza Strip against Israeli annexation or rule, but it was a cross-border attack in which Palestinians attacked within what is recognized internationally as sovereign Israeli territory. But I think the broader implication of your question is that Israel is not allowed, under any circumstances, to use armed force to maintain its rule in these territories, which is a rather separate matter than protecting its citizens. So, in other words, to put down an uprising against continued Israeli rule cannot by any means be considered legitimate self-defense under such a construction. And the court, I think, was quite clear that not only is Israeli rule in these territories illegitimate and illegal, but any policies Israel pursues to maintain its rule in these territories is just as illegal and unlawful and illegitimate.
And that was the point of my question, really, because the narrative has been that Israel is defending itself. And that's the point it's been insisting on, not just since 7th October, but previously as well. And
Sure.
I think this judgment just debunks that whole claim entirely, saying that because Israel does not have a right to defend itself, but it has an obligation. It doesn't have a right, it has an obligation to maintain law and order. And that's a completely different way of looking at the situation, as far as I'm concerned. You have
Yes,
to
if I can just interrupt you, because under the Geneva Conventions and the 1907 Hague Regulations, maintaining law and order is something very different than what we're seeing now. Clearly, genocide, clearly the systematic destruction of the civilian infrastructure of a territory and its housing stock and its hospitals and its educational institutions cannot by any stretch of the imagination be even remotely associated with the maintenance of law and order. And even then, maintaining law and order must be first and foremost in the interests of what's called the protected population, the population of the occupied territories, not the occupying power, and certainly not the illegal settlers who live in illegal settlements.
Yes, and thanks for that clarification. And I think in the minds of people, when you say Israel has a right to defend itself, it's almost like Western audience, you're primed to think, oh, Israel's just defending itself by bombing these hospitals and schools and whatnot. But you need to know, you have an obligation to enforce law and order, and then you go and bomb schools and hospitals. It changes the scenario completely. You have an obligation, not a right to self-defense. So I think it's an important point to highlight. I think, because we have been here before, 2004.
Yes.
The ICJ issued a judgment saying that the wall is illegal and the states should not support the illegal situation in occupied Palestine. So they made more or less the same conclusion and demand on the international community that all states should abide by this ruling and cannot support and defend this illegal situation. Is this different now? Because in 2004, not many states actually abided by the judgment of the ICJ. Are we now in a different place? And can they continue to ignore the ICJ ruling now? And what is the obligation that has been imposed on every every UN member?
Well, it's a very interesting question, and I think many of the elements of the 2004 wall ruling are incorporated into and reconfirmed by the current advisory opinion. That's number one. Secondly, the 2004 case dealt with a specific policy and a specific issue. The current one is much more difficult to ignore because it deals with the very existence of Israeli rule in the occupied territory. So it's much more difficult to get around, um, uh, if I can put it that way. So and additionally, the most recent advisory opinion imposes obligations not only on the United Nations, which requested this opinion, but on its individual member states, and says that they are all under an obligation, first and foremost, not to recognize any of the realities that the court has ruled are illegal, such as, for example, Israeli sovereignty over East Jerusalem, such as, for example, settlements, such as, for example, Israeli changes to the 1967 pre-1967 boundaries, and so on and so forth. Secondly, it obligates UN member states not to undertake any activities that would make it complicit in these illegalities. So, for example, the European Union, for all its talk about the rule of law and human rights and finger wagging at others, is actually the main engine of growth for the illegal settlements because it allows settlement products unrestricted access to the EU market. It spent decades talking about whether they're entitled to the same privileges that products from within Israel are given in the European market under the association agreement and other trade privileges. But the fact that these products are allowed into the European market at all would be akin to opening a store in the center of London advertising that you're selling blood diamonds. So that's going to have a significant impact, I think. And just as important, look at the Israeli response to the court's advisory opinion. You know, not only the usual, these are anti-Semites and Nazis and whatnot, but the core of the Israeli response from the top of the leadership all the way down, and including the opposition, was that the court has no right to pass legal judgment on our right to live in our own land. In other words, confirming the very claims that were the basis of this case, namely that Israel is not there as a temporary military occupier, but has had the intention from the very outset to permanently incorporate these territories into the Israeli state. And so I would argue that the Israeli response and the manner in which it once again denounced international law and international legal institutions confirms the verdict that was issued from The Hague.
And following on from that point, I mean, it's a really important distinction. The ICJ passed a ruling on the occupation and the nature of settlements, you can say, and they're all illegal. But the Israeli leaders, as you mentioned, and Israel for decades has not viewed the territories in separate ways. They see that as part of Israel, one and the same thing. And if we were to take that to its logical conclusion, if Israel doesn't extricate, and it doesn't have any desire to extricate, and it will not extricate from those territories, the occupied territories, then, and if the occupation is illegal and illegitimate, what does that make Israel? You know, if the occupation and Israel is one and the same thing, the occupation is illegal, the settlements are all illegal, what does that make Israel itself? I mean, well, is there an argument to say Israel itself is illegitimate if it considers all of historic Palestine Israel?
Well, that's a very good question. I mean, Israel, from the outset, for example, it considered East Jerusalem not occupied territory, but liberated territory. It renamed the West Bank Judea and Samaria. Israeli maps do not identify a boundary between Israel and the territories it conquered in 1967. There is no green line on official Israeli maps. Most recently, in his latest appearance at the United Nations General Assembly, Israeli Prime Minister Netanyahu held up a map that basically had the entirety of Israel and the occupied territories colored as one entity. And so these are key questions. I think there are two ways to answer your question. The first is to go back to the 2016 United Nations Security Council resolution, 23343224. It escapes me for the moment. But that, which is more binding as a matter of international law than almost anything else, obligated UN member states to begin applying what it called distinction in their dealings with Israel and the occupied territories. In other words, it had to deal with the occupied territories as a separate entity. And in effect, if you are going to apply that principle, then it's virtually impossible to deal with any Israeli entity, whether commercial or academic or military or whatever, because all of them are so thoroughly enmeshed in the occupation. So, and that's of course why Israel's sponsors and Western allies collectively and systematically ignored the Security Council resolution, and they will of course now attempt to do the same here. I would just like to add 2 points that actually, to the best of my understanding, the first scholar who made this argument about the illegality of Israeli rule in these territories was Norman Finkelstein, already almost 2 decades ago. And he wrote a very detailed, very lengthy legal brief making this case in the appendix to his book, Gaza, an Inquest into Its Martyrdom. And it's very well worth reading, for he sets out the case for the illegality of Israeli rule in these territories. He also makes an additional point, which I don't think was part of this latest advisory opinion, which is that there is no evidence Israel ever negotiated in good faith about ending the occupation, and that therefore helped clinch the argument. Now, the second point I would make is that this ruling was very specifically only about Israeli rule in the territories it occupied in 1967, and therefore did not at all consider the issues of the legitimacy of the Israeli state or even any of its policies within its internationally recognized boundaries. And that's one way of answering your question. The other way, of course, is to say, I think it's entirely correct that one can no longer make any distinction between the Israeli state and Israeli rule in these territories, and that whatever judgment one makes about Israeli rule beyond the Green Line is just as applicable to its structures and policies and so on within the Green Line.
Yes, and all that, of course, has happened incrementally over decades. Israel will insist West Bank is Sumeira. Jerusalem is the capital of Israel. And over time, Israel, as we know, has created facts on the ground, which, in my view, is a way of gaming the international system. Over time, the international community begins to recognize the new facts on the ground, reality on the ground. And we saw that with the 181 partition plan, 194 right of return of refugees. Israel, far as I recall, its membership of the UN was conditioned on recognition of 194 return of refugees. But we've moved on from all that, and never has Israel accepted those resolutions, those binding resolutions. And to me, it seems like it's been gaming the system. And I'm just worried now here. We have an ICJ ruling saying that the occupation is illegal, that the settlements are illegal, that Israel will not still continue to game the system, because there's two ways of looking at law. Law can simply be instrumental, that you use law to further your colonial intentions, or law could be the way most people view law, that we have to abide by the law. Israel does not think of international law in that way, that it has to abide by the law. It is gaming the international legal system to further its colonial intention. And that's been clear right from the get-go, from Resolution 181, 194, all the way to, I would say, the ICJ ruling. Can anyone stop Israel gaming the system? That's the question I want to ask.
Well, I would answer that in two parts. And the first would be to say that we should not understand law as something that exists in a vacuum, that exists independently of politics. Because, while legal principles may be neutral, I don't think they are, but let's assume for the sake of argument that they are. Well, legal principles may be that way. Their application and implementation, as we've been discussing, is very much determined by political realities. And here I would like to bring up Palestinian responsibility, because we were just talking about the 2004 advisory opinion by this court on the wall. That created enormous opportunities for the Palestinians to exercise pressure on Israel, on its Western sponsors and allies, on international institutions, to take measures to respect the outcome of that ruling and to begin implementing it, at least in part. Now, what happened that same year is that the Palestinian leader, Yasser Arafat, was removed from the scene by Israel and was replaced by Mahmoud Abbas, who in effect adopted a policy of non-confrontation and full cooperation with Israel and the United States. It's for that reason that so many of his own people view him as a quisling. But it was in that a decision was taken not to challenge Israel and not to place it in a difficult position that could arise from undertaking efforts to, to implement this wall ruling. Now, the second part of my response is, Israel has been, in some respects, very clever about gaming the system. I'll give you an example. You have UN Security Council resolutions 242 and 338. Israel, I believe in the late 1960s or early 1970s, accepted these resolutions, even though they speak of the inadmissibility of the acquisition of territory by war and the need to relinquish occupied territories. So Israel, on the one hand, accepted these resolutions. What it then said, well, if you look at the French version of that resolution may have the definite article, the occupied territories, but the English version speaks only about occupied territories, and therefore it does not apply to all occupied territories. And then, after Israel relinquished its rule on occupation of Egypt's Sinai Peninsula in the context of the 1979 Egyptian-Israeli peace treaty, Israel then made the argument, well, we've actually withdrawn from 90% of the territories we occupied in 1967, so we're not under an obligation to also withdraw from the West Bank and the Gaza Strip and the Golan Heights. Now, this interpretation was, of course, wildly popular, in the United States and in Europe and so on among elites and liberal intellectuals. But it's one example of how Israel games a system, and I think we have to recognize, often in fairly clever ways, where their objective is not necessarily to convince you, but to sufficiently confuse you that you lose sight of what the principles are that are meant to be upheld and applied and implemented.
Yes, let's move on. I think we've spent quite a considerable amount of time on the ICJ ruling. This is going to keep coming up. There's the ICJ ruling on the genocide, of course, and the ICC ruling, and there's developments
Yes.
every
If I
week and
could
month.
just make one final point, because I did mention the Palestinian response, or rather non-response, to the 2004 advisory opinion on the wall.
Sure, go ahead.
I think it's absolutely crucial now that Palestinians take the lead in pushing their allies, their adversaries, the international community, UN institutions, to keep the issues raised by this advisory opinion alive, and to add meat to these bones. Because if the Palestinians don't do it, no one else will. And this landmark ruling will die a silent death.
So I think many commentators have spoken about that with regards to the 2004 ruling as well on the wall, saying that there was a failure in
Yes.
marshalling and wielding what was a moral victory for the Palestinians granted by the highest court in the world. And I think you're right. We shouldn't fall into the same trap again. And it's up to the Palestinians to make use of this, what is a massive moral victory. Yeah, let's another big story from last week is, of course, the Israeli air raid on the port city of Hodeidah in Yemen. It killed 6, and I think over 80 were injured. Two things I want to ask you about that. How does the ability of the Houthis to target Tel Aviv change the calculation in the minds of Israel about the kind of threat it faces, if it does change the calculation at all, and also the fact that the Saudis were really quick to distance themselves from the attack, even though you cannot get to Hodeidah without going past Saudi territory. So they would have had to grant consent. But despite that, it seems Saudis were very quick to come out and say, no, we played no part in this. Has no relation or involvement in targeting Hodeidah, and the kingdom, Saudi Arabia, will not allow any entity to violate its airspace. That's the quote from the foreign ministry. So just those 2 points. How does it change the calculation if it does, and the response from the Saudis coming out that in the way they have?
Well, I think first we need to look at the Yemeni drone that was launched at Tel Aviv, and by all indications, it was not only not intercepted, but was not even detected. And this was a single drone. Now, the Israelis have subsequently put out all kinds of tall tales about, yes, we knew its exact trajectory, and we were fully aware of it, but then a human error led it to land in the very center of Tel Aviv, I think less than a block away from the U.S. Embassy, or the former U.S. Embassy, and other sensitive buildings. It's quite clear that the Israelis were caught with their pants down. Whether this was because, as the Houthis claim, that these are undetectable, let's say stealth drones, or if, as some reports have suggested, there was a diversionary attack that drew away the US and UK focus in the Red Sea, and subsequently the Israeli focus is unclear at the moment. But I think in many respects it's a game changer. I mean, when you have now a military force located at the farthest reaches of the Arabian Peninsula, having the capability and the political will to successfully launch a drone at the center of Israel's most important city, that changes a lot of things, I think. These are not missiles coming from the Gaza Strip, or anything coming from southern Lebanon. And I think it demonstrates that the axis of resistance, as it calls itself, throughout the region, is feeling sufficiently emboldened to begin tightening the noose on Israel. Again, this was only one drone. It killed only one person, but I think symbolically it is massively significant, particularly because, once again, all indications are Israel was unable to even detect it. And we also have had numerous instances in northern Israel where it has not had the capability not only to not intercept, but to not even detect incoming drones fired by Hezbollah from Lebanon. As far as the subsequent Israeli attack on the Yemeni port of Hodeidah is concerned, you read the Israeli press, and Israeli officials are open about it. We hit civilian infrastructure. Of course, to Western correspondents, they will say terrorist targets, Houthi infrastructure. But you read the Israeli press; it's very clear. We hit civilian infrastructure. This is the equation. You fire at us, we will destroy your civilian infrastructure. And of course, they hit a power plant and an oil refinery, and caused huge fires that basically made for a very good spectacle on television for Netanyahu's domestic audience and his acolytes in Congress for when he goes there this week, so he can play the tough guy. But just as importantly, the Houthis subsequently put out a statement that they are not deterred and that they will continue to launch attacks at Israel unless and until Israel ceases its aggression against the Gaza Strip and lifts the siege on the Palestinian population of that territory. There has been at least one more attack, I believe, aimed at Israel's port city of Eilat since then, and I think we can expect more, because Ansar Allah, the Houthis, have also said that they will retaliate for the Israeli attack on Hodeidah, and that the nature of that Israeli attack means that all bets are off, that it will no longer observe restrictions in its dealings with Israel.
And why do you think the Saudis were very swift
Yes.
to not denounce, but distance themselves from
Well,
the attack?
first of all, I don't agree with you that the Israelis could only have attacked Hodeidah by using Saudi airspace. They may very well have flown over from Eilat over the Gulf of Aqaba and into the Red Sea without going over Saudi territory. What is absolutely clear is that they must have had permission from the US-UK Western Naval Task Force in the Red Sea so that they would not be identified as hostile aircraft and wouldn't be engaged by those Western forces. There are also reports, unconfirmed as far as I know, that the Italians operating out of Djibouti, I think, helped refuel these aircraft en route. I have no idea whether that's accurate or not. But the Saudis have, the Saudis have been were engaged, some would say still are engaged, in a 10-year war against Yemen that has been a strategic disaster for Saudi Arabia. There's been a ceasefire between the Yemenis and the Saudis for almost 2 years now. And one concern of the Saudis is that they do not want the regional dynamics that have been unleashed by Israel's war on the Gaza Strip to demolish the quiet that they have along their southwestern and southern border with Yemen, because the Yemenis were also launching attacks on Saudi territory and Saudi infrastructure and so on. And we already saw this some time ago when this Western task force first assembled in the Red Sea. The Houthis put out a clear statement that any regional state that makes its airspace available to US aircraft or Western aircraft to bomb Yemen will be treated as a direct participant in hostilities and dealt with as such. And already at that time, you had, I believe, the Saudis, the Emiratis, and the Qataris stating very clearly that they would not be giving the Americans or others permission to overfly their airspace to bomb Yemen. And it's in that context, I think, that the Saudis were very quick and very firm to disassociate themselves from this Israeli air raid. Whether these are statements meant to deflect consequences and perhaps are not borne out by concrete reality, I really have no idea.
I mean, if I'm an Israeli watching all this, I'm seeing not only attacks from Lebanon, but also from Gaza, now from the Houthis in Tel Aviv. And I'm now seeing that the port of Israeli ports have become bankrupt. And the moral legitimacy of Israel is questioned by the ICJ, the top courts. And I'm thinking, many will feel that what is the future of Israel? They'll be asking, what should we be here? And I think many with passports, foreign passports, are leaving. And you see that from an article from the Times of Israel last week, which said that 285%, there was a spike of 285% of Israelis leaving the country. So I'm looking at all this, attack on Tel Aviv, northern Israel, southern Israel, Israeli ports becoming bankrupt, the moral legitimacy completely dismantled by the ICJ. I mean, you'd have to ask, has the Zionist project, the promise of the Zionist project, failed? The promise was to, create a state of Israel for Jews only. I mean, has that failed now?
Well, if these numbers are correct and Israeli Jews are fleeing Israel for large numbers to seek safety on foreign shores, it kind of undercuts the central premise of Zionism, which is that there needs to be a Jewish state because it is the only entity that can ensure the safety of Jews in an otherwise persecuted and violently anti-Semitic Europe. So there's that aspect. But, we don't know to what extent these are Israelis who have previously successfully acquired dual citizenship in, for example, Spain or Portugal as reparations for the mass expulsion of the Jews from Iberia in the 15th century. By the way, I should add a form of compensation that was never offered to the Muslims that were expelled at the time. But so we don't know if these are people who have decided to leave permanently or to sit abroad and wait and see what happens. But I think there's also two factors here that are worth mentioning. The first is that one of Israel's greatest successes since the Oslo agreements, and it was largely because of the Oslo agreements, was its comprehensive integration into the global economy. So, for example, prior to 1993, Japanese or South Korean corporations would often avoid Israel like the plague because of the Arab boycott, and they didn't want to jeopardize their commercial activities in the Arab world simply in order to cooperate with the much smaller Israeli market. So, for example, Japanese cars, you didn't see them often in Israel before Oslo. But as a result of that, Israel has been very successfully integrated into the global economy. Now, for example, you look at commercial relations between Israel and India, military relations too, for that matter. But the point is that what we're now seeing is a flip side of that integration, where while integration into the global economy has provided Israel with very many benefits, it has also made Israel much more vulnerable to the priorities of this global economy. So now, for example, you have many of these foreign companies who have been absolutely central to Israel's economic development in recent decades, relocating business activities abroad and taking many of their staff, whether expatriates in Israel or Israelis, with them. You now have many Israelis who, as a result of this integration, have many more opportunities abroad and are seeking to use these opportunities to get out of escape the current crisis. The other thing is that while it's certainly true that this government has substantial popular support in Israel, otherwise it wouldn't exist, and would never have been elected, it's also true that you have a substantial number of Israelis, including many who perhaps voted for some of these parties, now asking, do we really want to risk our well-being, our lives, our children's lives by sending them to the army for the apocalyptic visions of Netanyahu and the apocalyptic aspirations of Ben Gvir and Smotrich? And I think you're seeing that as a vote of confidence or no confidence, not only in Israel's future, but particularly also in the policies of its present government. They may speak one language when they're talking to outsiders, but when they vote with their feet, it tells a very different story. And again, I don't know how reliable these figures are, or if they are even what they mean, but I do think it's an important phenomenon.
Yeah, we follow that trend. Let's end with two questions about the US. First, Netanyahu is traveling to the US. I think it's the only place in the world where he will receive a red carpet. I think in his own country, there's protest every single day with hundreds of thousands of Israelis demonstrating, calling for him to resign. Of course, they still support his war or his campaign in Gaza. So why is he traveling to the US? I mean, does he need a confidence boost? It's the only place he'll get something like 50, 60 standing ovations when he speaks at the... And I'm thinking he'll probably defeat Trump if he was to stand against Trump, if he was eligible. So why is he going to the US?
We have to understand how passionately devoted US political elites are, not only to Israel, but to Netanyahu personally. If Netanyahu ran for the Speaker of Congress or the head of the Senate, he would win probably unanimously, or maybe there would be 2 or 3 to vote. He is passionately loved and idolized and lionized by the U.S. Political elite. He's much more popular than their own leader. These people can't get enough of him. He's everything they would like to be. The fanatic, passionate devotion of the U.S. political elite to Israeli leaders, whether it's Golda Meir or Menachem Begin or Yitzhak Shamir or Yitzhak Rabin, and now what's his name, Netanyahu. Never underestimate it. Never underestimate it. It is a love affair, the likes of which you will never see on the silver screen.
And I think we can talk next week when we do have another review about the content of that. But let's finish with a question about Biden. He's not going to be running to be the president of the US. So the question I think we should ask, I mean, no one else is going to ask, and will he be remembered for rescuing American democracy, as his fans are saying, because he now has pulled out of the race. Therefore, they could mount a proper challenge against Trump. So in that scenario, he'll be seen as a savior of democracy. But hanging over his head is the fact that he worked hand in glove with the Israelis in executing a genocide. So what will he be remembered for?
Well, I'd like to make several points. Biden is these days often being compared to former U.S. President Lyndon Johnson, and it's an interesting comparison. In 1968, in 1965, the U.S. passed the Voting Rights Act, finally giving the vote to millions of citizens who are not Caucasians and who had previously been denied the right to vote. So in 1968, the U.S. could legitimately claim to be a democracy. Johnson had intended to run for re-election, but as a result of widespread popular opposition to the U.S. war in Vietnam, Johnson indicated that he would not seek or accept the nomination, and that was the end of his political career. So, in other words, it was in response to popular opposition to his policies. With Biden, it's very different. He is not stepping back because of opposition to his supervision of and complicity in the genocide in Gaza, for example. He's not leaving because of opposition to any of his domestic policies. There's a very simple reason why he's no longer the Democratic nominee for president. It's because the major donors pooled their support. In other words, what was a democracy in 1968 can, in 2024, legitimately be described as a plutocracy in which people are allowed to vote for the candidates selected by the donor class. I really do think it's that simple. I think there's also
Can I just interject? I think
yes.
what confirms your position or your view here is the manner in which Biden made the announcement. It was over a tweet. As a statesman, you'd stand in front of the camera and say, "I no longer am going to be running for the
That's
president
what
of the
Johnson
US."
did.
Yes, and then say, "I endorse such and such a person," or say, "I want an open candidacy, election campaign," something like that. You'd be a statesman. You would not sit behind a screen and tweet that out. It's just such a shameful way of doing this. Sorry to interject.
Yeah, no, and also, I mean, another curious aspect, I'm speculating here, but right before he made his announcement, a day or two before, it was announced that he had COVID. And I was watching one of the major news broadcasters, I think it was CNN, and the reporter was pointing out, well, for someone who has COVID, not only is Biden not wearing a mask, but none of the people around him are acting particularly concerned that they're in direct unmasked contact with someone who was supposedly ill with this disease. And it makes you wonder whether this was kind of, let's say, the pretext that was used to drive the final nail into the coffin. But be that as it may, I think there's also another aspect in which Biden shares some similarities with Johnson. Johnson is rightly remembered mainly for his murderous war against people of Vietnam and Southeast Asia, but he also had many significant domestic achievements to his credit. And I think with Biden, it will, or at least should be similar. This is someone who had substantial domestic legislative initiatives to his name during his period in office. But all that took place under the shadow of direct U.S. complicity and participation in the genocide of the Palestinian people. And now people ask, assuming that Harris will be the nominee and assuming for the sake of argument that she will be the next US president, will there be a difference? Well, yes, there will be a difference. It's a difference between, the traditional unconditional support of Israel of US presidents and the fanatical devotion and commitment to Israel of Biden. It's a small distinction, but one nonetheless. I don't think we've ever before had a leader in the United States who openly and publicly and repeatedly proclaims himself an adherent of an ideology, in this case, Zionism, which is identified exclusively with a single foreign state. And with Biden, that's certainly been the case. His absolutely fanatic and unquestioning devotion to Israel and his determination to stand shoulder to shoulder through thick and thin, not only with Israel, but with its most fanatical leaders. People who make Trump look like the very personification of liberal democracy, people who would never be accepted by Biden and his crew, had they been operating in the US political system, but absolutely slavish devotion to them, to their policies, to their agenda, and to their genocide in the Middle East against the Palestinian people. You know, it's going to make, I think, for some very interesting historical, political, and I would argue also psychological analysis in the years to come.
But as always, Mouin, it's a pleasure to talk to you.
Likewise, thank you.
And I hope, and see you next week, and see you also for tuning in. Thank you also for tuning in, and see you in another review with me, Nasim Ahmed, and my regular guest, Mouin Rabbani. Bye-bye.